Good afternoon, ladies and gentlemen, and welcome again to another live broadcast of State of Our Nation. Now, first of all, some housekeeping matters. I must apologize for the absence of Attorney at Law and Senator Gregory Nicholls. He was supposed to be on the panel this afternoon. However, he's a bit under the weather, and we do wish him well and hope that he feels better soon. Um, however, last week, the issue of public officers' participation in elective politics outside of casting their ballot came to the fore for public discourse. Of course, we are speaking about the issue surrounding Democratic Labour Party candidates Pedro Shepherd and Mr. Alwyn Barb, both of whom are facing disciplinary action for allegedly violating the general orders of the Public Service and as well as the Public Service Act. Now, we don't want to get into the weeds too much as it relates to this specific case and the ensuing allegations about these charges being politically motivated. However, we do want to discuss the whole picture as to whether civil servants are being disenfranchised or discriminated against as it relates to their prohibition from participating in elective politics. Now, just to provide some context, Section 33.18.1 of the General Orders states officers and employees are expressly forbidden to participate actively in politics, including the following: A. Being adopted as parliamentary candidate. B. Canvassing on behalf of any party or candidate for election to the House of Assembly. C. Acting as agents or sub-agents for any candidate for election. D. Holding office in party political organizations. And E. Speaking at political meetings. Now, that's the crux of the matter as it relates to the public service, the general orders of the public service. Now, here with me to unpack as much as we can in the time span that we have is veteran trade unionist, Mr. Dennis De Peiza. He's also the general secretary of CITUSAB. Now, it is also important that we have youth involvement and youth perspective on key matters, especially now that we are a republic and we want to get their input as much as possible. And here we have joining us is second year law student Tyrique Wilson. And he would also try to help us as best as he can to determine if there are any parallels that can be drawn between recent constitutional cases decided in the court. Now, I must hasten to add that these rules in the general orders are by no means unique to Barbados. As a youngster growing up in St. Vincent, public servants, I remember like in the 80s, and I guess I'm giving away how old I am at this point, not that it matters anyway. But public servants used to be walking on eggshells around election season, as something as simple as being in a campaign rally wearing party colors could have cost them their jobs um, at that time. So, as I said, it's by no means unique to Barbados, but I think a good place to start, and I want to start with Mr. De Peiza on this issue. A good place to start is trying to get an understanding of the rationale behind these general orders. What were the drafters trying to safeguard against? In other words, what is the perceived inherent risk with the public officers participating in the electoral process? I'm not saying that you would understand that you would have understood you are in agreement with it, obviously, but I'm trying to get if it was either relayed to you in your capacity as a trade unionist, or if you just along the way garnered what the rationale would have been. Over to you, Mr. De Peiza.
Thank you very much um, for having me on the program, and good afternoon to my fellow panelists and to those who are viewing the program. Now, let's start where we can really begin, and that is with the history. And one would expect that piece of legislation, which you have to use the word archaic, part of our colonial history, that piece of legislation being held up in this modern era suggests to me that we are not progressing or not showing the level of intent to progress as we said we want to, because we've gone from the colonial era to independence, and we now turn ourselves into the Republican era, and yet we are talking about something that is outdated and whose history was grounded, as far as I'm concerned, in the basis essence of control. In the colonial past, one would understand why this was like this, because this obviously is dated way back in the 70s and even beyond. And this, the changes that were made um, in the amendments that came in the late 70s after the Honorable, the very excellent Albar made some, or proposed some attendant changes, was to make it progressive. But a lot of it has not been put into law. And therefore, what we have to understand from the very beginning, that the general orders cannot conflict with the Constitution. So that put to bed one nuance that would present itself. On top of that, we have to also acknowledge that basically the general orders were regulations, and their enforcement um, really could not stand in the law. But with the amendment, or let's say with the coming on stream of the Public Service Act, these have been drawn in sections of it into the Public Service Act, which of course then give some teeth to some of the components. But that historical base tells us that we need to revisit, and at the point where we are talking about constitutional reform, maybe this was a timely intervention, one would put it, to bring to the light or to the fore one of the issues that we need to address, and address in a very firm manner, because we cannot be on one hand speaking to the issue of promoting in the freedoms and rights of the person, and still walking in the very narrow corridor of denying people their fundamental rights and freedoms. Now, if you look at the history, you would say, the ILO conventions, Fundamental Convention on Human Rights, which are applicable to all member states of the ILO, whether they put it into effect or not, and Barbados has adopted those. So if we are saying that we identify with the fundamental rights and freedoms of the individual, how could we, in practice, be making a case to deny persons those rights when we, in truth and in fact, want to build a youth society where we have people to enjoy those rights and freedoms, and that we vigorously protect them, so that we do not walk in the dark corridors of the 40s, 30s, and beyond, but obviously in an era, as I said, where we are speaking about making progress, being progressive, and most fundamental of all, treating to the whole notion of a society where discrimination is not the norm or not part of the norm. We are standing very strongly against that. So I would like to think that when we debate or or we enrich our discussion going forward, that we can look at some of the thoughts that have presented themselves, and we will want to suggest that there's a need for reform in order to put us in a new place at this time.
Okay, that's quite a mouthful, Mr. Peiza. I want to bring in the younger panelists at this stage. Now, the courts appear to be taking a very dim view of legislation that run counter to those that legislation that conflict rather with the constitutional freedoms of assembly and association. The High Court recently, in the prison officers case, handed them back the right to join a trade union, reversing that 40-year-old legislation. Now, I'm going to help you by providing some context here also within and the listeners as well, in terms of sections of the Constitution which can be brought into this debate. Now, you're looking at Section 21 of the Barbados Constitution that states that persons have the right to assemble freely, and associate with other persons, in particular, to form or belong to political parties, or to form or belong to trade unions or other associations for the protection of his, and I am substituting, or her interests as well. Section 44 of the Barbados Constitution only prohibits three categories of persons from seeking to be elected to the House of Assembly. Those are judges, the Director of Public Prosecution, and the Auditor General. And if you're looking at precedent as well, you're seeing Trinidad. They took the decision to um, allow public officers to run for public office, and then allow them to, if they are not successful, to return to their substantive jobs. And in 2019, the High Court in St. Kitts and Nevis, they struck down that section of their Public Service Act that prevented public officers from participating in the general elections, as they deemed that to be unconstitutional. So, Tyrique, come in at this point and tell us your thoughts, if there are any parallels that can be drawn at this point as it relates to that.
Okay, firstly, I just want to follow any sentiments around Mr. De Peiza, and thank you for having me on this evening. With relates to your original question, though, I suppose, by relating to what would justify these orders, particularly Orders 3 in the General Orders and Sections 24B and 24E of the Public Service Act. And I think that it is necessary for us to engage an analysis, a brief analysis, albeit, of the separation of powers doctrine. Perhaps there is where we can find some justification for these general orders or for these provisions in the Public Service Act. So a superficial view of the separation of powers doctrine does mandate or does prescribe that there ought to be the separation of the legislature, the executive, and the judiciary. However, I find that an often overlooked tenet of the separation of powers doctrine is the intra-branch separation of the executive. And what this seeks to do is this seeks to separate the command of the political directorate from those civil servants. And I think the case of Thomas versus AG had referenced it when the court used the language of insulating members of the civil service from the political power directly exercised above them. So that when we look at these general orders, perhaps these are an expression or expressions, legislative expressions of that tenet of the separation of powers doctrine. With regards to the case law and how the case law has handled these provisions, however, as you rightly noted, the case of Leon Nelson versus the AG of St. Kitts recently contemplated this similar issue, and they ruled that the provisions in the general orders and the provisions in their conduct and code of ethics were in fact unconstitutional. Perhaps you can delve into why they found them unconstitutional in a few minutes.
Okay. But as it relates, I mean, and that's a very interesting perspective as it relates to the rationale. But as it relates to the whole idea of it contravening this, do you think that you can find a parallel as to determine if there's a contravention, of the Constitution as it relates to the general orders?
Yes, and I think that when you pointed out Section 21, I think it was about freedom of association. That was an accurate place to look. And by extension, I would also add in Section 20 of the Barbados Constitution, which speaks to freedom of expression, because most of the case law does contemplate freedom of expression. When we think about the right or the protection of the freedom of expression, you would see explicit mention to politics, to an individual's ability to express on matters of political nature, such that when you consider sections 24B and E of the Public Service Act, and you consider sections 3.8, 3.18, etc. Of the general orders, these inherently and innately limit the freedom of expression and the freedom of association. But of course, we have to bear in mind that no right is absolute. So it would be remiss of me to make a hasty generalization, just to say that because these limitations are imposed by virtue of the Public Service Act and the general orders, that they are indeed constitutional, unconstitutional, that is, such that prima facie, I guess we can say that they were unconstitutional. But of course, having regard to the rationale that I previously espoused, that would be the means of which we have to actually analyze whether or not they would be constitutional and whether the inherent limitations of the general orders and of the Public Service Acts unreasonably limit the right to freedom of association or freedom of expression.
Mr. DePiz, I see you chomping at the bit to jump in here. Go right ahead.
I'm very intrigued with Tyrique's intervention. Suffice to say that a basic point has to be made. Nowhere in the Constitution of Barbados denies public officers in the main outside those three to whom we have spoken to earlier, or who are identified in the judiciary and so forth. It does not deny teachers from participating in elective politics. And that's why I made the point from the outset that the general orders cannot override the Constitution. But what is even more disconcerting is the inconsistency within the general orders itself. We made the point when you spoke to section 3.18.1 that speaks to the fact that public officers are being denied from taking part in politics. But then we have the section 3.19, which goes to the contrary, because it speaks to the whole idea of casual employees are, however, permitted to speak at political meetings and stand for election in the House Assembly. Now, who is a casual employee in the public service? Because, or I should put it differently, who is defined as a public employee in the public service? And anybody paid from the public purse has to be a public employee. So here, we, on the one hand, we are denying a set of citizens the right to participate, freedom of association, freedom of expression. We now learn that has been struck down by the High Court of Barbados. So how dare someone attempts to flout the ruling of the court? That's basically what I'm saying, to suggest that can't stand. We believe we have the right to more or less, again, to break the law, if I may say that, for you were trying to speak over and above the Constitution. So that, in my mind, is a fundamental issue. And it has to be more so put into context, where the Employment Prevention Discrimination Act of 2020 also makes it very clear. The Act in Barbados is saying that you, whether intentionally or not, you can't make a distinction that creates an exclusion or shows a preference, the intent of which is to subject the other person to any disadvantage, restriction, or other deterrent. Now, if that is the case, how could we stand and make a case that public officers should be denied a right to participate? And I would like to quickly turn the attention to the case. This was only in 2019. And the judgment of that case is very interesting when you read it. And if you permit me, I'll just read a few lines of it. It said, in deciding whether any such restriction is constitutional, the court must of necessity consider where to strike that balance, paying close attention to the need to preserve the impartiality and neutrality of public officers in order to preserve public confidence in the conduct of public affairs. However, for reasons explored more fully, there is no lawful restriction on the ability of public officers to participate in political activity, and the court cannot pronounce on a restriction that does not exist in the matter. And this is precedent has been set in the region. This is not the only Caribbean island has had this a contest of this matter before the law courts. So I'm wondering, what is the motive? What is the reason that in Barbados, senior public officers, because that's the ones who are going to be fueling this, I am not going to say politicians, because politicians, as far as I know, don't manage the public service. So why is this matter being pushed and to make a case that really cannot be justified? That's the question I'd like to have answered.
Tyrique, I see that Mr. De Pisa is speaking in absolute terms here, as it relates to the matter. You see it differently. You could expound on your point if you wish at this point.
Well, just to clarify, I don't necessarily see it differently than Mr. DePisa does, but I understand, by virtue of being a law student, that the law is perhaps a bit more delicate, and it has to be treated as such when we engage certain constitutional questions. So just to revert to the earlier point that Mr. DePisa made with regards to the extent that the Constitution only precludes three types of judicial officers, not judicial officers, three types of public officers from entering in elections, that might be true. It probably is true. But we have to understand that, as I said before, no right is absolute. So although the Constitution might not expressly preclude certain civil servants from entering into elective politics, surely, having regard to the separation of powers doctrine that I had expounded on earlier, it could provide some justification as to why these orders still exist. Now, with regards to the case that Mr. DePisa just mentioned, Leon Nelson versus the AG, the court was, as he correctly cited, the court was in favor in ruling the provisions of their code of conduct and ethics as unconstitutional because they recognize and they understand that in a democratic society, surely in the interest of democracy, it would be incongruous to allow this broad-reaching order with no differentiation with regards to civil servants, just a broad-reaching blanket restriction, as we would call it in law, to affect civil servants' ability to enter into elective politics. Now, that is not debatable. I do agree with the ratio in Leon Nelson, but what I was trying to do is to establish first the rationale and then get into the analysis of whether or not it would be constitutional or whether or not it would be unconstitutional, which I think is the latter. Now, turning to the point as to whether or not, or as to why a case has been brought, unfortunately, it seems as though somebody has to be brought before the court for these issues to be addressed. And although it might not be the best route to go insofar as contentious litigation, it provides us an avenue to answer questions of constitutionality and questions of law that had not been previously contemplated. Because we can look at it for a fact. Before this case was brought to the public's attention, nobody, perhaps generally, was having discussions or having discourse about the content of the public service or the content of the general orders, such that a case like this now propels us to answer these constitutional questions.
That actually is a very good point, Mr. De Pisa, and that's one question I want to get back to you on. Now, prior to this case, with the two senior officers, was this issue on the union's radar as a matter that needed to be addressed? What and if it was, what were the logistical stumbling blocks preventing it from being dealt with prior to this?
I'm happy that you've asked that question because speaking from the CEO of the Congress and Trade Unions, this has been long a matter that we have been putting before the Office of the Attorney General, and we have been trying to have this matter addressed. This is no secret. We have been flagging it. As a matter of fact, it is currently still very much a part of our statement of policy document. We have been trying to get the discussion going. I can say to you that the Barbados Union of Teachers has it as part of their collective bargaining agreement document that they were trying to conclude with the Ministry of Education. And I'm sure that document must be dated as much as 8 years old or more, and it has never been concluded. So this is not an old issue. We've been consistently speaking to it because we believe that the fundamental rights of teachers, in this case, but public officers largely, were being abridged. And the history of that tells us that because that we have continually articulated the position that we want to have freedom as we speak to the conventions 87, 98 to be observed as they are should be, we are being straightened in our positions on these matters. I would dare say to you that despite our pleadings, just as we did with the case of the prison, let me say the protective services, which is the police, fire, and prison, we have been struggling with that matter from way back as 2005, and it has taken to 2022 for a ruling to be made in the favor of the citizens of this country. Although they wear uniform, that they have rights. And I think that it is about time that we understand that the labor movement is just not looking at convenient times to jump up and scream about things. We see these matters, we raise them, we flag them. The press gives us let's say a little front page on the matter at the time, but the press never continues its work in trying to push the agenda. So it appears in the front line that it's dead. Far from, because we look at our writings and our mouthings continually, we are speaking firmly to these matters. So I would like to think that in this case, this matter has, I guess, I would say, come at the appropriate time. I would say, in the intent of it seems ill-advised, but we are grateful because it gives us the opportunity to put it to bed once and for all. And I'm hoping that in the constitutional reform that we are undertaking, that the wisdom will prevail and will, as a progressive society, will move to make the change that we would hope we would want to see. As I speak, the Constitutional Working Group of CIDUSAB is currently meeting. It meets every 2 weeks, and it's trying to ensure that we put together a body of proposals which we will submit our recommendations. Hopefully that people will take note of, and we will have an aim that we work valid and see the transformation and the changes that we believe that will help us to build out a better society. And I will say, in making this point, I hope you would just entertain me briefly. I have a document here which comes from the Office of the High Commissioner for Human Rights. And this is a document updated from of the 57th session of 1996. Okay? And it speaks to the whole question of the right to participate in public affairs, voting rights, and the right of equal access to public service. But what is important in the document I would want us to draw from for the listener's attention? It says where a mode of direct participation by citizens is established, no distinction should be made between citizens as regard their participation on the grounds mentioned in Article 2. That I said no unreasonable restrictions should be imposed. So even at the level of this of the UN, this has made a significant comment, and this is general comment number 25 for those who want to research it on the right to participate in public affairs. And if this comment has the universal impact that we believe it has, then I believe that we should be having or proceeding to follow the type of exemplary behavior that we would expect from our managers and leaders within the country.
But what has been the stumbling block, though? I mean, you mentioned that this has been now almost 8 years or more that you have been holding discussions. Is it what has prevented any traction? Is it a case where it seems to have just been falling on deaf ears, or what has been the stumbling block?
Well, you struck the exact chord. It's more than 8 years. I spoke to 8 years in relation to the Barbados Union of Teachers Collective Agreement. But the issue that we are speaking to here has been put on the table with the labor movement long ago. All I'm saying is that successive governments have just put it I call it the file 23 or file 13. Conveniently, everybody does not want to touch it. I believe that it has taken us so long, but we have come to a point where it has now to be addressed. And I'm happy that the court, as I said, I want to repeat myself, address the outstanding matter of the right of people to freedoms of persons, and consistent with that judgment, I cannot see how a ruling on this matter could not be follow suit, because it would, to me, I would wonder what to think if on the one hand the court would say, okay, you have freedom of association, and on the other hand, and struck it down in one fell swoop when a basic violation again is being made. But this matter is not one that we have not been pushing, as I said, but have not been getting the traction for whatever reason that I can speak to. I can say to you, we've gone through several attorney generals with this. I mean, from the time of the current prime minister, especially with the attorney general, right down the line, this has been on the table. This is not a new issue.
Tyrique, do you think this matter? I know that we still have to go through this. We still have to go through the stages. Obviously, it has to go to the public Ministry of the Public Service to be where it will be deliberated there as well. But do you think we should head straight to the courts so that we could have some a final decision on this matter once and for all?
I think that perhaps a two-pronged approach ought to be adopted, because when we look at the general orders are what we consider to be secondary legislation. So it doesn't necessarily require a robust judicial process in order for them to be removed. So perhaps that deliberation at the Ministry of Public Service, which deals with the public service, perhaps that ministry could address the specific issue of the content of the general orders. With regards to the specific provisions in the Public Service Act, however, that to me requires a bit more robust discussion, and that to me would warrant a judgment of the court, just so we can have it there in law. The judicial stance on the content of the Public Service Act. So of course that would look like a challenge insofar as the infringement on the freedom of expression, the infringement on the freedom of association, such that the court can deliberate it, declare as unconstitutional, and pursuant to the declaration of unconstitutionality, then is when the ministry or the legislature would engage in the process of reforming that specific part of the Public Service Act. But with regards to the general orders, as I said before, that requires a less robust intervention. So that would just require, as you said, discussion perhaps at the level of the legislature, insofar as reforming it as it is indeed secondary legislation.
Your thoughts on that same question, Mr. De Peiza?
Well, as a trade unionist, I believe that we are always able, we have the ability to negotiate matters. And once we can have the partner system at the table, there's no need for litigation. We can have this resolved by looking at, as we go through other pieces of legislation and make input. This can be done in a similar way, because we all understand what is the problem. It is as clear as day. And sometimes we use the cliche clear as mud, but for some of us it's a little darker. But the point I'm making is that it is so obvious that it constitutes a major problem that makes us look stupid in the eyes of the world, because we cannot have our cake and eat it too. So if we can sit down and have a civil and rational discussion, and of course look at the documents to make them into what I said, modern, workable regulations and even go as far as laws, then we are on the right track, because that is what we want to see. That's what we preach. We speak all about the engagement of the partners, talk about the dialogue and the collaboration. This is an opportunity for us again to be able to come back to the table in the way that we have construct our model and to do the right thing.
Okay. Now, I have another question for both, and I'm going to pose this to both of you. And I'm no legal luminary by any stretch of the imagination. But the fact that only two persons were caught in this dragnet, and the allegations are that there were many more that would have participated on political platforms during the last election in January. Can you find some legal argument in that as well? Starting with the younger first, Tyrique.
Well, in my opinion, I'm not sure if I could construe a legal argument right now. As you know, in court, hearsay is inadmissible or only admissible in certain circumstances. So it would be wrong of me to cast any judgment on who or whether or not there were more people who would have engaged in political activities during the election but weren't called before the courts. So perhaps I would refer this question to Mr. De Peiza.
It's interesting that I'm not politically charged in that direction, but I can ask you. I have to put this on. because I think that we are all aware, those of us who reside in this country, about persons who have been on the campaign trail. In other words, there has been a practice of this. This is nothing that has just shot up in the last election. So we know of persons who come to our doors, in our homes or communities, who are public officers, whether teachers or other administrators, campaigning on behalf of people. We know those who are branch secretaries, on all other office holders in the branches of the various political parties. You see, I'm saying that there's a level of hypocrisy in this whole thing because we all know only in the previous election, we had a teacher who went on the platform and spoke on the other party side. That matter blew up, and in the same breath, it blew away. We know of people who have been on social media during the last election campaigning for one or other side of the political divide. So why is it that it appears that there is an attempt, I think, to embarrass or to sully the names of two professionals? One would admit, and I personally would, yes, the law is the law, but one has to consider the circumstances. This is nothing new about what is happening here. In other words, the practice has been going on for time immemorial. I would not, because of course, legally, this is not the correct thing to do. If I were to call list, I would call a list of names, and a list, I mean a list, comprehensive list. And I would challenge anybody to tell me that I'm wrong. Because I know, and a lot of us in Barbados know, people, yes, we have persons who go into the polling booths or work on the election day, but they might be covered because they're working for the state on that day. But outside of that, there are others who are doing the legwork and are members of the parties and do all of the other things that they're required to do without interference. So I'm just saying that it sounds and it comes across as though there is something is not right in this instance. And maybe if you want to say you want to make an example of someone, then there's a level of procedural matters that one should have exercised. I would stay at that because this matter is being dealt with, and I would not want to go into any strategies or matters that would not want to be made public at the same. But it is really something that boggles the mind in how the whole thing has proceeded up to this point.
Okay, we are getting to the winding down stage of our program. So at this stage, I'm going to give both participants a chance to have their final say on this issue. And I must say, it has been a very intriguing discussion thus far. And we will start with Mr. De Peiza. Your final thoughts on this issue.
Well, I've been saying all along, these are matters that we are happy to have on the table, simply because it gives the opportunity for us to treat to them and to resolve what I would say is a breach in the rights of persons that we have been seeing over time. But it lays for a better society, because if we want to bring our funds our best to the fore, it cannot be limited as traditionally it has been to those people who, like my friend Terry, who are in the law chambers and the persons who live in the financial hierarchy of this country. Those who have the ability, who we educate, we probably pride ourselves on giving free education, who become knowledgeable and who have all the what is required to do the job. Let those people have the opportunity to input into the management of our country, the leadership of our country, and to chart our way forward. Yes, there are constraints, and we accept that there may be some groups, because of, even in the current constitution, would prohibit, as happened in the United States. Under the Charter of the United States that was passed in 1993, there are some persons that are restricted. People in the federal government, like the Federal Elections Commission and the Secret Service and the intelligence for the defense and security. Yes, and that is understandable. But you cannot take the people who we have as part of our intelligentsia, who are going to make a better Barbados, and tell them, oh, you cannot contribute. Then where are we going? Nowhere. no be fast, it will say. So let us be different in our thinking as we move forward into a new era and to make the changes that are necessary. If we are saying that we are identifying with all of the international conventions of the ILO and the UN and so forth, then demonstrate by practice that we are truthful to our cause and remove those scales from our eyes.
Yes. So just to recap my arguments, as we would have previously mentioned, Section 20 and Section 21 respectively devolve the right to freedom of association, to freedom of expression or freedom of association. However, it's important to understand that no right is absolute, such that rights can be limited in situations where reasonably required. If you look at Sections 24B and Section 24E of the Public Service Act, we see inherent and innate restrictions on the aforementioned rights of freedom of association or freedom of expression. Further, when we look to the general orders, particularly Section General Orders 3.18, rather, we see a doubling down on this limitation. With regards to the rationale behind them, in my view, it is basically to enforce a reasonable, or basically to enforce the separation of powers doctrine, specifically the intra-branch separation in the executive, which mandates, pursuant to Thomas versus AG out of Trinidad, that the civil service ought to be insulated from the power of government and the influence of government directly acting upon them. Notwithstanding that justification, however, it is important to note the current state of the law, particularly having regard to the case of Leon Nelson versus the AG, Fraser versus the Attorney General, which regard these restrictions as overly broad and blanket restrictions, which have no place if we are to promote democracy. And with that being said, if the two parties that we have mentioned previously are brought before the courts, it is more than likely that these general orders will be struck down, and the provisions of the Public Service Act, specifically Sections 24B and E, pursuant to the aforementioned cases, would be held as unconstitutional.
All right. Now that brings us to the end of our program. I want to thank both panelists for joining us this afternoon. Mr. Peiza, you are accustomed to me calling on you on a regular basis to provide insight on various issues on trade union matters. Tyrique, I think you are a new find for me. I'm quite impressed with your articulations as well. And the future of Barbados seems to be in very good hands. And I will be as well reaching out to you from time to time as a resource person on some issues. It's always good to get the voice of youth on issues of this nature. So again, I want to thank everyone for joining us, and I want to wish everyone a pleasant and accident-free Easter weekend. Thank you again, and do have a pleasant evening.
Thank you for having me.